Welcome to the Brain Injury Association of New York State's webinar, Post-Concussion Syndrome, Schools and the Law. I am Carla Giovaniello, Brain Injury Training and Services Project Director here at the Brain Injury Association of New York State. Thank you for joining us. Before we begin, a few housekeeping details. Questions can be submitted during the webinar via the question text window. The text box option should be visible to you on the GoToWebinar toolbar on your desktop. If you are having trouble viewing this option, please contact Citrix Tech Support at 1-800-263-6317. Again, that number is 1-800-263-6317. This number should also be visible on your toolbar. Our presenter will do his best to answer questions in the order that they are received. Any questions he is unable to address may be submitted via email to the association. We will be recording this webinar session and plan to post it, along with the PowerPoint slides, to our website, www.BIANYS.org. Information about contacting the association and viewing the webinar will also be provided in a follow-up email after the webinar has concluded. Before I turn the microphone over to Bruce, let us begin with a quick poll to see who is in our audience today. Please take a moment to answer the question. All right, I'm going to close the poll. It looks like we have a lot of people here in that other category. I'm curious to know who they are. No athletic directors or coaches, but we do have some school-based medical professionals, teachers and counselors and school administrators. So we do still have some diversity here. Thank you all again for joining. I'm happy to have so many people in participation. It's a very serious topic here. And it is with sincere pleasure now that I introduce our webinar presenter for today, Mr. Bruce Goldstein. Bruce is senior partner with the New York State law firm of Goldstein, Ackerhalt Pletcher, a firm focusing its practice in the areas of special education, disabilities law, estate planning, and special needs trusts. He possesses over 30 years of experience, has received numerous honors and awards, including the New York School Psychologists Association Friend of Children Award and the National Parent-Teacher Association Lifetime Membership Award. He is also a nationally known speaker. Bruce, good afternoon.
Good afternoon. Hello, everybody. Sorry you can't say hello back, but I'll assume you're doing that. We want to make this as helpful to you as possible, so as Carla said, as you have questions, please send them to her. She's the one who will receive them, and she'll then relay them on to me for me to try to make this a little interactive, given that we're doing this, in the high-tech way. So let's get started. And first I want to talk about the Individuals with Disabilities Education Act, or IDEA. Many of you may know about it, so I won't go into excruciating detail, but I think I can give you some new insights possibly. First, in my view, and I've been doing this for a few years, the IDEA, I think, is one of the most powerful laws on the books in the U.S. Having said that, any law really is just words on a piece of paper or on a computer screen. It's a tool. It doesn't automatically work itself out, and when it doesn't work right, there is a lot of access for families and opportunity for families to get those things that their child may need. Having said that, a tool is only as good as the person who is using the tool's training and skill. And the IDEA is a very complicated law, and as a result, unfortunately, Many parents need the assistance of someone. An attorney typically, advocates sometimes can be of assistance as well. So remembering that, then knowledge is power, and let's talk a little bit. The jargon and principles in the law, FAPE, standing for Free Appropriate Public Education. Appropriate is, well, free obviously means no cost to the family. Public education means either provided by the school district or arranged by the school district. Appropriate, that's the term that us lawyers love because everybody disagrees on what's appropriate. You get three people together, you got three opinions. But every child who qualifies under IDEA is entitled to a free appropriate public education. That's to be provided in the least restrictive environment, LRE, but the LRE that is appropriate. If it was just least restrictive environment, every child would be in a typical class, and that's not always the case. If appropriate, the child should be in the regular education classroom with supports if necessary. But always remember, because school districts have a tendency sometimes to forget, that it's the least restrictive environment that's appropriate. So there may be more than one appropriate placement. If there is, then the one that is the least restrictive is the one to be selected. This was originally developed CSE, which is the term in New York State. We've had cases all around the country, and I've heard every state, many of them have their own terminology. The generic term is the IEP team, and the term IEP, which stands for Individualized Education Program, which is what every child under IDEA gets. Then the IEP team is the one who determines what that IEP should say. The parents are members of that IEP team, so they have full opportunity to participate. But if there is a disagreement, that's where, although consensus is supposed to be pursued, you can't always get consensus. If that's the case, then whoever's chairing that IEP meeting is the one who's going to decide, and that person obviously is a representative of the school district. Having said that, parents, and you'll see in a moment, have an opportunity to disagree, and there's a mechanism for parental disagreement. I've also put in here child find, because child find is extremely important. In the IDEA, there is a provision that says that school districts have an affirmative obligation to locate and identify every child with a disability. So, if a school district has a basis to suspect, not conclude, suspect that the child may qualify, may have a disability under IDEA, then the school district's obligation is to refer that child into the special ed or IDEA system. That starts with an evaluation of the child, of which the parents have a right to say, no, I don't give consent, and that typically is the end of the process. But if the parent consents to the evaluation, then the process goes forward, culminating in an IEP team meeting to decide, is this a child who should qualify under IDEA and should receive an IEP. As I mentioned a moment ago, if the parent disagrees with the recommended IEP, or for that matter, if the IEP team says this child is not disabled, and the parent disagrees and says, no, I believe my child is, in any of those situations, parents have a right to go to due process. They have a right to an impartial hearing with an impartial hearing officer. That hearing officer is not an employee of the district. It's a third party. And then, if the parents prevail, they have a right to get reimbursed for their attorney's fees by the school district. So that makes this law much more accessible for families, that although the attorney's fees will typically have to be fronted by the parents if they're successful. If they are a prevailing party, which is the term under the law, the district has to pay. There, on a practical level, that typically means most of the time, you can't count on it, but most of the time, there will be a settlement because the school district will have a cost itself to going through the hearing, even if it wins, and of course if it loses, it's also got to pay the other side's attorney's fees. So the law makes it very clear. There are two parties, essentially, to this whole process. The school district and the family, each is equal. Each one cannot move forward without the other, and if there is a disagreement, then we have a dispute resolution mechanism. In other words, a hearing. With that said, there are classifications under the IDEA, labels, if you will, 13 different labels. And since we're talking about post-concussion syndrome and really talking about brain injury on a more global level, there are essentially two classifications or labels that can apply to the population we're discussing today. One of them is the classification of traumatic brain injury, TBI. You can see on the screen in front of you, here is the definition to qualify. Note, it's an acquired injury. So if a child is born with a brain injury, that might be internal, then they won't qualify under this classification, but they could qualify under another. Similarly, this would not cover someone who maybe had a stroke or a bleed, a brain bleed. Because you see, it's an acquired injury caused by an external physical force, resulting in impairment. And at the end, this is critical. All 13 classifications really have this explicitly or implicitly, that adversely affects a child's educational performance. The IDEA is an education law, a special education law, if you will. And in order for a child to qualify, he or she must have a disability that affects the child's ability to learn. If you have a disability that does not affect the child's ability to learn, this law is not going to apply. We will, near the end of this session, talk a little bit about Section 504, which is another law that could apply if a child does not qualify under IDEA. But to be under IDEA, to get an IEP, the child's learning must be adversely affected by the disability. TBI applies to open or closed head injuries resulting in impairments in one or more of these areas. And I'm not going to, just read this to you. You can obviously read this for yourself. I'll give you a moment. Note that all of these areas relate to the learning process. So, but again, it's going to have to impact learning. Another classification that is available under the law is what's called other health impairment, OHI. And having limited strength, vitality, or alertness, including a heightened alertness to environmental stimuli that results in limited alertness with respect to the educational environment. That is due to chronic or acute health problems and, again, adversely affects a child's educational performance. So OHI, which tends to be somewhat of a grab bag, or can be, can cover the population that would have a brain injury, post-concussion syndrome, etc. Again, you got to apply this on a case-by-case or individual basis to see if it would apply for the child. I want you to know that these classifications, these labels, they're like the key to the door. In other words, you have to qualify within that label, that classification. But if you do, that opens the door. Once the door is open, then the child's needs must be met, even if those needs are beyond or in addition to or comorbid, as we might say, to the head injury. So once you're through the door, it's like the keys to the kingdom. You get all these rights, regardless. It's not limited then at that point just to that particular classification. Now, having said this backdrop about classifications and getting access to coverage under the law, then the question becomes, as I mentioned before, that right to a FAPE, free, appropriate public education. What is appropriate? What is the definition of appropriate? What's the standard that a child is and a family are entitled to expect and that a school district is obligated to provide? Well, the very first case decided under the IDEA, had a different name at that point, was the so-called Rowley case, R-O-W-L-E-Y. Dealt with a young girl named Amy Rowley. She was actually in a school district, the Hendrick Hudson School District in New York State. She was deaf, and she was in first grade. She was a lip reader. She wore hearing aids. She was in a regular first grade class, and she was doing reasonably well. She was in the upper half of her class, and she had what we might call a resource room. In other words, she got some special ed tutoring, she got some speech therapy, and she also had what was called an FM unit. For those of you who don't know, that would mean that the teacher would wear a microphone with an FM transmitter that would transmit directly to something connected to her hearing aid, so it would close the distance gap, be as if the teacher were talking directly into the hearing aid. But because of her deafness, that didn't mean that she could understand the sound that she was getting, and she needed to have speech reading or lip reading to supplement that. Her parents, who, by the way, happened to be deaf, not necessarily relevant, but they were concerned that even the best of lip readers don't get 100%. We can debate how much, but she was getting less than all of the information, and they, since they were deaf and they used sign language at home, although they wanted their daughter to be oral and speak and lip read, they asked for an interpreter to also be put on the IEP for Amy. And the issue became then for the Supreme Court, was she entitled to that interpreter or not? Now, you've got to understand the role that the Supreme Court plays here. When the Supreme Court justices are considering a case, they really have two responsibilities or issues to deal with. One is obviously the particular case in front of the judges. But on the other side of the coin, they know also that whatever they write in their opinion deciding that case is going to set forth principles, because they have to justify why they are deciding in a certain way. And once they put that in writing, there's no way they can even imagine all the different permutations and combinations of factual circumstances that will come out later, where courts all over the country are going to be dealing with different individual cases, different disabilities, different children, different ages, different circumstances. But they're all going to look to this decision, this Rowley decision, for guidance on the principles to be applied. So you might think, well, why wouldn't the Supreme Court just say, we're going to say that appropriate means we're going to maximize the potential of Amy Rowley? Isn't that what education's about? We want to maximize every child's potential. So what's the downside of doing that? Well, the downside is that if you really did a maximizing standard, whatever the school district would be doing and however much money they may be spending, they could always do more. There would never be an end. It would essentially break the bank for school districts. So that was not a standard that was acceptable to the Supreme Court. Now you might say, well, how about we want to provide Amy and children who qualify under IDEA with an equal opportunity, an opportunity equal to children who are not disabled. That sounds like mom and apple pie, doesn't it? I mean, of course we want to have equality. Well, the problem is that how do you actually operationalize that? If you think of an equal opportunity, we're not saying an equal outcome, just an equal opportunity. Nonetheless, when we talk about equal, you've got that equal sign, right? So on each side of the equal sign, it's almost like a scale. On the one hand, we've got Amy on the one side, but the question is, equal to what? What do we compare that equal opportunity to? Well, we could say, I suppose, an equal opportunity to the other children who are not disabled in her classroom. And what would be wrong with that? Other than, obviously, we're looking at that kind of abstractly, and we can't really quantify that explicitly. But the problem becomes, what happens the next year? When Amy's in a different class with different children, does her opportunity change because of the mix of the children? And if we try to rectify that by saying, okay, well, not that particular classroom, we'll take the school building. Well, you know, what happens if her family moves? I mean, she goes to a different school building. Does her opportunity change? And if we say to all the children in the state, I mean, that's really getting large. And of course, at the end of the day, the practical implications of this equal opportunity just don't work. Because we're talking about a federal law that's to give every child a right, and that right should be the same, whether that child is in New York State, Mississippi, California, Colorado, whatever. It shouldn't depend on the mix of children or the state. It should depend on that child and what that child's right is, and that child's right should be the same wherever he or she is. So, again, equal opportunity, that doesn't play out. So therefore, what did the Supreme Court do? The standard they set is the child's IEP reasonably calculated to provide educational benefit? That is the standard. However, there is a little nuance, and that nuance is quite significant. When you look carefully at the Supreme Court's decision in Rowley, there is another portion that relates that says the child must receive sufficient educational benefit. This has since been interpreted by some courts as meaningful educational benefit, not minimal. Well, for those of you who want black and white, it isn't there. The court recognized that every child is different, and therefore there is no one-size-fits-all. So the court explicitly said in the Rowley case, this is going to be a case-by-case determination. The court said, insofar as Amy is concerned, she does not get the interpreter. She didn't get the interpreter for a few reasons. The court said, number one, that passing from year to year is a significant factor in determining is a child receiving an appropriate education. Amy was in the upper half of her class, and of course this is, you know, compared to her non-disabled peers. So in their view, although passing from year to year is not the only factor, it's not a determinative factor, it is a significant factor. Not only was Amy passing from year to year, she was actually in the upper half of her class, so in their view she already was receiving an appropriate education, therefore she did not need the interpreter to get a FAPE. But this case-by-case determination, we have to look at every child in terms of his or her capability compared to how he or she is achieving. Is the child getting meaningful educational benefit, sufficient educational benefit, case-by-case determination. Now, let's look a little bit more at this FAPE notion. An IEP has to set out a lot of information. Included in that information is a statement of the child's present levels of academic achievement and functional performance. In other words, kind of a baseline. What we call the PLEP, present levels of educational performance. So we have something to measure against. And then we want to look at how the child's disability affects his or her involvement and progress in the general ed curriculum, which is the same curriculum as for non-disabled children. Now remember, we're going to have some children who are very low functioning, and that leads to other issues as well, because they may need in their curriculum more than just the general ed curriculum to meet their functional needs. But every IEP must set forth this information. And then importantly, excuse me as I locate my cursor, there must be a statement of measurable annual goals, including academic and functional goals that are designed to meet the child's needs resulting from the disability, allowing the child to be involved in and progress in the general ed curriculum, and note, meet each of the child's other educational needs that result from the child's disability. Now going back to the top of this, measurable annual goals. The law is very clear. There must be measurable criteria in those goals. Why? Because how else are we going to measure progress? And the IEP says that there must be periodic progress reports relating to these goals that are to be shared with the family at the same time that typical report cards go out. And so we measure the progress, and then if there's an annual review, meaning everybody comes together at least annually to take a look at the IEP and talk about the next year's IEP, we have a way of determining how successful were we or were we not. Now, it's very important to understand there's some science here and there's a lot of art. The science piece is there must be measurable criteria. The art piece is, what is the goal? If we have a child who achieves all of his or her annual goals, that could be a very good thing, or it could be not such a good thing. Because if the goals were set too low, the child met all the goals, but maybe we should have been aiming a little higher, and the child could have achieved more. On the other hand, a child who doesn't achieve all his or her goals, that may be okay. We aimed a little high, and maybe it's not a bad thing to aim a little high if we make good progress. So that's the art part. And it's tough for families who are not trained and educated in education. They rely on the educators in the district. Most school districts are doing the right thing. Unfortunately, there are obviously those who don't necessarily do the right thing or don't know. And of course, depending on how common the disability is, they are sometimes more or less knowledgeable about what to do. I'm going to pause here a moment. Have any questions to this point? I know I'm so interesting here that nobody has any questions because I've covered everything. I'll move forward. So issues relating to a population of post-concussion and brain injury and the like, the transition point, the time when the child is coming back to school, very, very critical period. I think everybody would understand that. It's important, in my view, that there be this kind of full team approach. Parents have to be integrally involved with the school district and with the outside professionals. And the discussion should not be the day before the child's returning. It shouldn't be the week before return. This is something that should be discussed well in advance so there's the opportunity to have things in place and ready. And likewise, I think it's very important, if not critical, that an individual for the, I've got LEA, that's the local education agency, otherwise known as school district. There should be someone specific, a specific person designated, whether that's the case manager, the contact person, the liaison, the coordinator, whatever title you want to give that individual. Their job is to coordinate with everybody, family, teachers, other staff at the district, outside professionals, home instructors if they're involved, who have been involved, are going to be involved, whichever, so that everybody's on the same page. Because if you don't have that linchpin person, I'm telling you that the odds are slim that things are going to go close to smoothly, because everybody's going to be coming at it a little bit differently. This linchpin person is critical in my view. Now I want to shift gears a touch. I want to talk about another part of the IDEA. It's potentially very powerful. It's called transition services. And the definition of that is a coordinated set of activities for a child with a disability designed to be within a results-oriented process focused on improving the academic and functional achievement of the child, to facilitate the child's movement from school to post-school activities, including post-secondary education, vocational ed, integrated employment, etc., depending on what that child's capability is. So what's the big deal here? Okay, well, number one, this whole concept of transition services, from my perspective, can be a very powerful tool. Let me make it clear. The law says that transition services must be in a child's IEP no later than age 16. That's under the federal law. Some states are earlier. New York State, for example, is 15. But under the federal idea, age 16. That means the year, the IEP that covers the year in which that child turns 16. So if the child's birthday is January 18th, then the IEP that starts the previous September must have transition in it. And the law goes on to say, which is not often used, but it is available, must be in the child's IEP in the year in which they turn 16, or earlier whenever appropriate. So depending on the child and the child's needs, if the child needs transition services earlier than age 16, then that would be a responsibility for the district to put it in the IEP. So what is this all about? Well, from my view, to simplify it to some degree, this requires a life plan for the child. The whole concept of transition services is to aim for beyond the horizon. In other words, a child is entitled in most states to continue in public education and have an IEP until the child turns 21, unless the child would graduate with a high school diploma before. Whether that is 21 or whatever the age is going to be when the child leaves the public school system, no longer has an IEP, this transition services says we got to aim for where are we heading over the horizon when the child leaves the public school system. What are we aiming for long term? And once we know that life plan, then what we ought to be doing is building backwards. Up to now, without transition services, we have annual IEPs. We look at one-year slices of a child's life. With a transition plan, transition services in the IEP, we say this is where we're aiming long-term. Now, each annual IEP is a stepping stone to the life plan. So we don't look in just one-year chunks. We now have to look long-term and build backwards so we can build up to the long-term goal.
Bruce, we do have a question from someone in the audience. The question is, in some instances, a student sustaining a TBI may suffer temporary effects that qualify the student under IDEA, the IDEA law. Do you recommend in that instance that a child be identified, and if and when they recover full function, they would then be declassified? How do you determine when to identify the student?
I think it's 37 and a half days. No, just kidding. It's a good question. I mean, it's subjective, but depending on the anticipated duration, if it is literally short-term temporary, in other words, we're looking at something that is only going to be a few months, 2, 3, 4 months, by the time you get done developing the IEP, if the child's going to be recovered, it isn't going to be worth it. On the other hand, how long is long enough is going to be, I can't give you a black and white, but the question ultimately, if you think in terms of the process to get an IEP, typically is going to run you at least 60 to 90 days to getting the IEP. And so then, is there going to be an IEP in place long enough to make a difference for the child? If the answer is yes, then I think it's worth it. If the district, however, is going to say no, and then by the time you fight it, well, it may not be worth the fight if the child's going to be recovered by that point, because you won't really get what you need. But on the other hand, if the district is willing to cooperate, and you can see there will be enough benefit, then it's worth the effort. There is also the 504 plan that would also potentially be available that we'll talk about in a little bit. So hopefully I've answered your question.
Thank you, Bruce. We have one more that just came in.
Sure.
Can the IEP be developed during the summer so that it can be in place when school starts, therefore not losing essential school time?
Absolutely. On a technical level, yes. IEPs can be developed at any time. Having said that, many school districts don't hold as many IEP meetings over the summer because of staffing issues. One of the requirements for that IEP team I spoke about is the child's teacher, or at least a teacher of the child, must be included on the IEP team. Well, you know, if the teacher's away for the summer because he or she is not employed, and if you only had one teacher, then that would be difficult. On the other hand, you know, at a post-secondary level, not post-secondary, secondary level, you might have multiple teachers, and if you get one of them, that would be sufficient. But given union contracts and the like, many times districts can't not require a teacher to come in. So trying to get people together, trying to pull that team together sometimes can be difficult in the summer. But leaving that aside for the moment, there's no reason otherwise not to have it over the summer. You want to have the IEP in place one way or the other before the start of school. The law actually requires that.
Thank you, Bruce. We have several questions just popped up. I guess we'll take a little question break here, if that's okay with you.
Sure.
One question is, how long does a district have to get an IEP in place?
The length of time is a reasonable period of time. I know that's not very helpful. The federal law has basically left that to the states. So each state is going to have their own regulations of the time frame from the time a child is suspected of being disabled and referred into the system for an evaluation to the time that the IEP team has to meet, make a decision, and then if the child is found to be qualified for an IEP, the time to implement that IEP. That's going to be a matter of state law. So it is going to vary for that first time. After that, there are annual goals. So remember that the goals in an IEP are for 1 year, and you have to have a new IEP in place before that old IEP expires. It's supposed to never be a gap. So that will govern. But remember also, any time that a parent believes there is a good reason for the IEP team to reconvene because something's not working right, something should be put in the IEP, something should be taken out, changed, whatever's the case, the parent has a right to request the IEP team to meet. You don't have to wait to the anniversary meeting, the once-a-year meeting. You can call for it to meet sooner. The time frame within which the district has to do that, again, is a creature of the state, each state, but under federal law, a reasonable time. Next question.
Another question we have asks, can parents initiate the child find services?
Absolutely. The child find obligation falls on the district, but the parents are always in a position to refer their child into the system saying, I suspect my child has a disability, I want my child evaluated, etc. And that, once that parent sends that in, that starts the clock ticking and the process rolling, and the district must respond to it. They can't just sit on it. The way to do it, I always recommend, in writing. Phone calls tend to get lost, and I never got a phone call. Put it in writing.
Okay. I have two questions that are somewhat linked. One has to do with the personal experience. I'll read it word for word. My daughter was in advanced academic classes in her freshman year of high school when she was injured at school playing softball. She has been diagnosed with post-concussion syndrome. The school wants to drop her down to basic level classes. Since she, her neurologist, and I all want her to stay at advanced level, they made me sign a waiver to stay in advanced classes, and they are very reluctant to provide accommodations the neurologist and neuropsychologist want provided. Since she is already an above-average student, similar to the Amy Rowley case you were talking about, am I wrong to push for the accommodations?
I think that, well, I guess to some degree it depends on what accommodations you're looking for. If you're looking for some testing accommodations, some additional tutoring or things of that sort, whether the IEP is going to really apply here, maybe not because of the Rowley definition. But hang on for the 504 discussion because the 504 may come in your situation.
I think that might be relevant to the next question, actually. It was asking if there are mechanisms of support available for kids with post-concussion symptoms that are expected to recover over a period of months.
It is related. I can tell you that under 504, again, which we'll talk about shortly, is there is a recognition that a temporary disability can qualify. No black and white, clear, bright line. The example that often is given is, somebody breaks their leg, saying in a skiing accident. Well, if it's going to be a couple months, they don't probably qualify as a person with a disability getting a 504 plan. But if there's complications and it'll last for a few months longer, then that individual may very well qualify. So it's a very subjective length of time as to whether you qualify, and I suggest hold on a little bit. You'll get a little more insight when we talk about what is the definition of a disability under 504.
Okay, I have two more questions and then we'll kind of segue. We'll keep going here.
Okay.
A lot of questions are popping up, but I'll try to break them up. The two questions that came up are: do schools have to follow IEP recommendations from an outside evaluation, such as a neurological evaluation? If not, what options do parents have?
Okay. Outside evaluations, once they're shared with the district, the district has an obligation to consider the outside evaluation, but it does not have an obligation to follow it. Now, having said that, school districts and IEP teams must act in good faith. They must act based on logic and rational thought. So, if there's an outside evaluator that says X and the school psychologist, for example, or someone inside the district says Y, and they're disagreeing, well, question number one, who's got the credentials to make that determination? If they both do, then the school district can rely on their own person if they want to, but they have to at least consider the outside evaluation. Likewise, they may be providing complementary information, but the outcome of the recommendation might be different. So after considering it, if the school district can articulate reasons why they're not following it, that is their prerogative. If parents believe that the district really hasn't given a good consideration, or for whatever reason has come up with the wrong conclusion, which they don't believe is justifiable, then you've got that dispute resolution mechanism I talked about, the right to go to a hearing. And at the hearing, the family would present the information from its outside professional and say, this should be followed, and there's no justification for the district not to follow it, and then the district is going to have to justify its position, and that impartial hearing officer will ultimately make a decision one way or the other. And then there can be appeals from that if necessary. But that's what a parent's opportunity is, to go to a hearing if the district doesn't agree.
Okay, and the last question before we continue on. If a child acquires their TBI after the age of 16, should their IEP immediately include the transition plan?
I'm going to give you a very long answer to that. Yes. And literally that's yes. From the time the child gets an IEP, or if the child had an IEP for some other reason and now has TBI, once the TBI is recognized, then and there's an IEP for the child, and the child is already hit age 16, then you're already the transition should be in right from the get-go. Okay.
Yep, and that concludes the questions, and we can continue on.
Okay. So going back to our slide on transition services, then, what I want to do is just briefly go back through this, but with a different perspective. I want to play the role of advocate. What is an advocate? My definition of an advocate is somebody who takes this tiny little opening and tries to drive a truck through it. So let's go back through this and see if we can drive a truck through it. A coordinated set of activities. Well, to me, if it's a coordinated set of activities, then you're going to have to have somebody who's the coordinator. Because how else do you coordinate unless you have somebody who is the coordinator? It's designed to be within a results-oriented process. That means, what are the expected results? And if we don't reach them, that means we better come back and figure out, all right, how are we going to get there a different way? It's a results-oriented process, focused on improving the academic and functional achievement of the child with a disability to facilitate the child's movement to school post-school activities. So we've got to sit down and talk about what is the potential for this child long-term, that life plan issue. And once we identify that, then work our way backward. So that's how I take that as an advocate. And let's just continue on with this, because the transition services also says that the transition services must be based on the individual child's needs, taking into account the child's strengths, preferences, and interests. It includes instruction, related services, community experiences, development of employment and other post-school adult living objectives, and if appropriate, daily living skills, etc. Again, with our advocate hat on, based on the individual child's needs, which is always the case for an IEP, taking into account the child's strengths, preferences, and interests. This is the first time we see this in the law. The child's preferences and interests. when we're not dealing with transition services, the school district is going to talk about what's appropriate for the child. These are the programs we have, and we work together to develop that. Now we're looking at the long term. Where's the child going? If Johnny wants to be a disc jockey, then maybe we got to think about what does he need to develop to be able to be a disc jockey. If Mary wants to be a firefighter, what are we going to do to develop her to be able to be a firefighter? We have to look at the child's preferences and interests, as long as they're reasonable. If we had a child who's got a significant brain injury and wants to be an astronaut, maybe that's not going to be reasonable. We got to look at something else. But if it's reasonable, then we got to talk about that. And that includes instruction, related services, community experiences, and the development of employment and other post-school adult living objectives. So the school building and the classroom, the four walls, are no longer the sole setting for this child's education. We now have to look at the community as the classroom. So let me give you, and I don't like to do war stories, but I'll give you a case I had several years ago. It was a girl. She was a junior in high school. She was an honor student, no disability, went on a skiing trip, and somebody on a ski board lost control and made contact with her head and unfortunately severed the hemispheres of her brain. The result was that she ended up operating at the 2nd percentile in terms of auditory processing. Her ability to understand the spoken word alone was at the 2nd percentile, very low. So we worked with professionals. We tried to develop a visual curriculum for her to be able to proceed. But 11th grade, social studies, math, etc., we couldn't do it. It just wasn't doable. So we took a step back, and we ended up developing a plan for her IEP based around transition services. She had good artistic ability, so we decided that our long-term goal, our life plan, was she would go, we were trying to get her into a post-secondary art institute, where if in that post-secondary art institute she would not be expected to succeed in the classroom, in the academic classroom, but she would be able to succeed on the production of art and the development of her artistic talent. In order to get into a post-secondary art institute, she had to have a portfolio. So we built an IEP. She exhausted all the art programs that were available in the high school in the district, and then the school district contracted with artists in the community. So she would go for an hour or two a day for opportunities to see her friends and socialize and so forth in the classroom and elsewhere, and then she would be transported off the school campus, and she would go to somebody, an artist, to work on oils, another artist to work on watercolor, another one to work on sculpture, etc. And she developed her portfolio, and she ended up getting into a post-secondary art institute. That is transition services. That is community experiences. That is the community as your classroom. That's how far you can take this transition services. So please keep that in mind. Let's shift now to 504, because this has come up a couple different times. The IDEA, remember, is an education law. 504 is a discrimination law. It's not an education law. It says that any entity that receives federal financial assistance, federal money, cannot discriminate on the basis of disability. So, hospitals are covered by 504. They cannot discriminate on the basis of disability because they get federal money, Medicare, Medicaid. If there are federal grants to museums, the museums are covered by 504. The Americans with Disabilities Act was patterned after 504. But the reason why we focus on 504 is because school districts obviously get federal money. They're governed by 504, and 504 was around before the ADA. When we talk about discrimination based on disability, it's two prongs. First, don't treat the person any differently just because they're disabled. That's the same as any other discrimination law. We don't treat somebody differently because of their race, because of their sex. Why? Because it's not a good enough reason. We don't treat somebody differently just because of race or gender. Same with disability. However, the difference with disability discrimination is sometimes you need to actually treat the person differently because they have a disability. You've got to do something extra. What is that something extra that we talk about? Reasonable accommodation. For example, you can't take somebody in a wheelchair, stand at the top of the steps leading into the building, wave at the person in the wheelchair and say, "Hi there, I'm not treating you any differently than anybody else." Well, that doesn't work. You got to do that reasonable accommodation. Got to put a ramp in, a lift, something. Well, reasonable accommodation, as we well know, for other disabilities that are hidden, still, because you're not building something, doesn't mean that it's not a required accommodation. Every school must comply with 504. And so when you think, for example, of extracurricular activities, if a reasonable accommodation is necessary, then it would have to be provided. Now, digest for 15 seconds what I just said. Can't discriminate on the basis of disability, must provide reasonable accommodation. Everything I've just talked about is not what I want to get to. What I just talked about was the generic requirements under 504. However, there are 7 regulations under 504 that are specifically and explicitly applicable to public schools. And the 504 regulations, there's only 7 of them. When you look at the IDEA regs, they go on and on and on. I mean, they are, there's just not a million of them, obviously, but, many, 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 many more. And they're very detailed. 504 is very vague. But we see some terminology that's very interesting. Under those regulations, school districts must provide to students who qualify under 504 a FAPE, which obviously we've seen before, free appropriate public education in the least restrictive environment. Now, what is appropriate under 504 may be different because we're talking potentially about a somewhat different population, but nonetheless, the same terminology. And how is that determined? It's determined by a 504 team. So it's not an IEP team, it's a 504 team. They don't develop an IEP, they develop a 504 plan. Now, interestingly, under the regulations, it never says the plan has to be in writing. But, of course, everybody's going to put it in writing because otherwise everybody will say it says something different. So you put it in writing anyway. And those regulations have a child find provision. So the school district has an affirmative obligation to locate and identify every child who is suspected of having a 504 disability. And you have a due process right. You have a right to go to a hearing with an impartial hearing officer, and if you prevail, the attorney's fees have to be reimbursed by the district. So we've got this kind of parallel universe under 504. And it has a lot of similarities to IDEA, albeit much simpler and a little more vague. So what is a 504 disability? Someone must have a mental or physical impairment that substantially limits a major life activity. Okay? Well, if we're talking about post-concussion syndrome, we're talking about brain injury, a mental or physical impairment, we've got that. And then you must show a substantial limitation of a major life activity. if the major life activity that is substantially limited is learning, the child's going to already qualify under IDEA, under TBI, other health impaired, whatever. So 504 basically is looking at disabilities where the limitation, the impact, is not really on the process of learning so much, but rather is on some other major life activity. Now, what might that be? Well, it can be walking, talking, breathing, speaking, thinking, organizing, or whatever else some clever lawyer might think up. Doesn't have to be a lawyer. I'm just being facetious, but the point is there are some examples, but it is non-exhaustive. So however you define it, major life activity can be pretty encompassing. So when we go back to those earlier questions about temporary, remember I said temporary applies if it's long enough. And if you need the accommodations, whether it's extended testing, because we're going to give that equal opportunity, because the child can't focus, can't concentrate on an ongoing basis for as long, so we need to provide the opportunities for breaks, modified testing, break it up. You can go on and on, whatever meets the needs of that child, as long as you can identify a substantial limitation of a major life activity. And then let me just go to the last one, and then we can see if we have any more questions. In that definition of 504, remember, mental or physical impairment substantially limits a major life activity, or someone who has a record of such an impairment, meaning they no longer are impaired, but they were before. Well, then you can't treat them differently because they once had the impairment. Or somebody who's regarded as having such an impairment. Doesn't apply to our population. And my last point that you need to know, because unfortunately many school districts are not, for some reason, haven't kept up on this. The law used to be that whether you had a substantial limitation, you would look at mitigation. In other words, is there medication being taken? Is there, somebody with a visual impairment wearing glasses mitigates? It used to be you would look at the person with the mitigation as to whether they were substantially limited. In 2009, the law was changed, and now we look at the person without the mitigation. So we look at them in the worst light in determining whether they qualify for substantially limited, and therefore qualify under 504. So that's the 504, which is a parallel universe to IDEA and available for the population we're talking about on a case-by-case basis. Any questions?
We do have one question. I think it's related to the initial question that was asked a while ago. It says, my daughter has post-concussion syndrome and documented trouble with memory, concentration, and focus. She has a 504 with the school. Wouldn't an IEP be more appropriate and powerful?
The answer on whether it would be more appropriate, let me take your second question, or second part. IEPs are more powerful, I believe. 504 plans can be, but an IEP is a stronger vehicle if you can qualify. So now on the question whether it would be appropriate to have an IEP, we have to look at what impact is this having on the child's educational performance. Is she, if we look at before and after, do we see a noticeable difference? If we do, then you can say that she would qualify because it's adversely affecting her educational performance. It's adversely affecting her learning. If, on the other hand, we're seeing a minimal impact on the learning, albeit struggling a lot more, then you may not be able to get the IEP because you're not going to be able to document that significant impact on learning. So that's what you have to look at. And using an outside professional can be helpful sometimes in that regard to try to assess that. You're documenting, you said, the ability, memory, and concentration, I think you said. Then I would expect if you can document that impact, it's probably playing out academically, albeit sometimes you get teachers who think they're helping and aren't because they may be bending over backwards to get better grades. But as long as you can show the impact, then pursue the IEP.
Okay, I do have a few more additional questions that popped up. One is, where do students with learning disabilities, processing speed or working memory deficits who have the capacity to do advanced placement or honors classes fall? These students are often denied access to advanced classes and magnet and or charter schools, and the attitude of the school is that these students should be in their school. I'm sorry, the last part is cut off, but I guess should be in their school of zone is what it says. I don't know if whoever asked that question could provide some clarification there.
I think I may have a feel for that. If you're talking about a magnet school and yet somebody says, no, the child ought to be back in their kind of zone or neighborhood school as opposed to going to the magnet school. The answer on this is that, as I mentioned, to get the IEP, you have to have this adverse effect on educational performance, on learning. So if the child is achieving highly, then it's going to be hard to get an IEP because now we're back to that Rowley situation, okay? However, you might be able to still get the 504 plan because if you can show that it's not learning that's the major life activity that's substantially limited. Excuse me, I'm going to have to cough a second. Sorry about that. If you can show it's something else, the ability to concentrate, the ability to attend to tasks, the ability to organize, whatever it may be, and you can get that established as a major life activity, then you get the 504 plan. If you get the 504 plan, you can potentially, under a 504 plan, get accommodations of extended testing time, separate location if you need that, being able to, with the extended time, take some breaks, things of that sort that might help accommodate at least on the testing level. And then you could potentially get extended time to hand in assignments, break down assignments into smaller pieces, any number of possible accommodations. So the 504 plan still might be a possibility even if the child is achieving well academically.
Thank you, Bruce. Another question that came up, is mitigation not considered for vision with corrective glasses or contacts?
Good question. I'm sorry I skipped over that. There are a couple carve-outs from the mitigation, and eyeglasses is one. I think they did that on a practical level because many of us, that's me included, wear eyeglasses, and they didn't want to have to deal with the non-mitigation issue for folks who can get their vision corrected with glasses. So there are a couple carve-outs to the general rule that mitigation is irrelevant, and eyeglasses is one of those carve-outs. So you look at the person with their eyeglasses. Thank you.
And Bruce, can you just explain that aspect, the mitigation of the impairment? One person in the audience would like it if you use maybe a different example just to explain how the mitigation of the impairment is not considered with the 504.
Sure. Give you a couple examples. A child has diabetes and if they are monitoring their blood levels, maybe they have to take insulin, but they do, and by doing that, they are not substantially limited. The mitigation, the law as it relates to mitigation now says we're going to look at you when you're exacerbating, when you're not controlled. Likewise, there was a line of cases for nut allergies, and they said, well, a nut allergy is not a substantial limitation. All you got to do is avoid eating nuts or being exposed to nuts. And the law now would say, no, no, we look at the child at the point when he or she is exposed to and responding to exposure to nuts, and therefore the child would qualify. You could have the child with asthma, and you're going to look at the, when they're exacerbating, not when they're taking their medication. You could have the child with ADHD, who with Ritalin is controlled, but we're going to look at the child without the mitigation, without the Ritalin. Those would be some examples.
Okay, if you could, yes. I know that there's someone in the audience that would just like it if you explained a little bit about why you might have to choose a 504 over an IEP. I know you mentioned the IEP is a little bit stronger of a vehicle, but this person just wanted you to kind of clear that up for them.
Well, I would choose the IEP over 504 if it's available, and that's a big if. Because the regulations, number one, are much more explicit, so you end up with a lot of additional rights under IDEA because you can point to explicitness. There's a whole bunch of case law that's developed under IDEA, much more than 504. 504, those 7 regulations are somewhat vague, and you're going to potentially be fighting over things that are vague as opposed to having clear, explicit rules under IDEA. School districts are also, you don't have to hit a district over the head under IDEA as much because they're so used to dealing with it, because the numbers of kids who have IEPs are much more number-wise than under 504. So school districts, their application of 504 is less frequent. So you've got this vagueness, you've got this lack of frequency, and as a result, you're potentially, the school district says, well, we don't do that. Well, that doesn't mean you're not obligated to do it. Whereas under IDEA, it's probably, if it hasn't been fought out in that district, there's a good chance there's something similar under some case somewhere else in the U.S. that you can point to, and therefore IDEA tends to be more powerful. But if you cannot qualify under IDEA, 504 technically is there to assist. It's just that you're going to have to possibly push a little bit more to almost educate the district a little bit about what their obligations are under 504. I hope that answers the question.
Thank you, Bruce. We are running low on time. We do have some more questions. Bruce, I know you said you don't mind going a little over, so I just wanted to announce if anyone has questions, please get them in now. If you have a question but you have to leave and you don't think you'll be able to get it in time, please send it in an email to the association. Again, you will be getting all this information in a follow-up email, and I'll be happy to get it to Bruce. The next question I have here is, are you familiar with New York's recent concussion law? If so, do you think the concussion management team, as described by the law, should be overseeing the student's return to school and activity, or is that role better served by the school physician or school nurse?
It's a good question. And now you're talking about under the assumption that there's not going to be an IEP or a 504 plan. Because if there is an IEP or 504 plan, I'd rather see that govern because you got rights. But short of that, then I like unless you've got a specific comfort level with the nurse or the physician, I like the idea of the team. It's a little broader group, more perspectives. I like them governing better. As long as you got a coordinator.
Thank you, Bruce. The next question is, under IDEA, the law does not call for medical documentation of a head injury for the student to be considered eligible, does it? And would a head injury as a result of near drowning, anoxia, or lack of oxygen be considered a TBI or non-traumatic?
Good question. Let me take the first question first. I think if you're going to be talking about a brain injury, you're going to need probably some documentation in some fashion. Typically, that would be some medical documentation of the injury. Having said that, I think most school districts are going to say, we either want an evaluation and a note from a doctor or a report documenting the brain injury, or at a minimum, there's going to be copies of some medical records that show that there was a diagnosis of a head injury. It's not explicitly required by the law, but implicitly, I think there's going to have to be some documentation of that injury to qualify. I think most school districts would insist on that. And then the question of the, say, drowning or anoxia, I would argue that that does qualify. It's coming from an external source, and I think what they were trying to avoid under the definition was the stroke or the brain hemorrhage or things of that sort. So I think the external cause causing the anoxia I think would be sufficient.
Thank you. The next question I have, which also relates to the definition of TBI or acquired, I know you were talking about acquired brain injury, shaken baby syndrome. Someone in the audience would like to know if that qualifies since it's a result of an external physical force.
The answer in that is yes. I think that, in my view, shaken baby syndrome would definitely qualify.
The next question I have, what cautions, and I apologize about the wording here, I believe the person meant to write, what cautions would we make or should districts make employing an RTI approach in response to students re-entering school following a TBI?
RTI, which we could go on for about a half hour on, but I'll try to take it very briefly. RTI has two different meanings, okay? In the special ed world, when you look at the federal law, RTI only appears as a means for diagnosing a learning disability, not for diagnosing any other of the 12 of the 13 labels. So technically, RTI as an evaluative tool to determine does the child qualify under IDEA would not be appropriate for TBI. Now, there is another RTI, which is, they meld together, but which many school districts view RTI as a regular education initiative, the concept being one size does not fit all. And for those children who struggle with our standard curriculum and standard methodology, we're going to have a multi-tiered approach that tends to try different strategies and more individualized and so forth. And at some point, after we've tried a few different approaches, if it's not successful, then we'll refer the child into special education. So that could be the RTI the district is thinking about. But the bottom line is, again, child find. Is there a basis to suspect that the child has a disability? If the answer is yes, the child must be referred in. And remember, as we said before, the parent, if the district doesn't do it, the parent can do it by making the referral of the child to be evaluated. And as I pointed out, once you refer the child as suspected of disabled, RTI is not a proper evaluative tool for TBI.
Thank you, Bruce. I have another question. It's a little bit of a different topic, so I'll give it to you and see what you say. Do you think schools or medical professionals should administer and interpret baseline testing for school athletes?
Well, you're talking about if we're concerned about concussion and we want to kind of get some baseline so we have something to compare potential impact, I think it's a great idea. Then we've got a mechanism that we can come back and take a look at what impact, if any, if a child is concussed. So I support it.
A couple more questions and then we'll draw a close. Again, if you did not get your question in, please don't let it fall to the wayside. Please email it to the association, and again, I'll be happy to get it to Bruce. I'll take a few more questions before we bring it to a close here. Considering how critical the student's re-entry into a school or learning environment is for the student's long-term success, would it make sense to immediately get a 504 plan into place with a student, even if an IEP evaluation process is in the works?
That's a tough one to call. I could envision instances where that might be a good idea. So at least you got the 504 plan in place while you're waiting for the IEP. On the other side of the coin, if you think you got a strong situation to get an IEP, I'd be a little concerned maybe that having the 504 plan might undercut people pushing to get the IEP. Because they'll say, well, you've already got a 504 plan. There's nothing, if you pull it together, one ought to be able to move the process faster, hopefully with a cooperative school district. There's nothing that says you have to take a long time to get an IEP. You could theoretically speed things up if you feel it's necessary. So I'm afraid I can't give you a yes, I feel that's a good idea. No, I don't feel it's a good idea. It's one of those case-by-case determinations with pros and cons. Thank you,
Bruce. I appreciate it. So 2 more questions here. If there is there any language in the 504 or IDEA law that specifies that the diagnosis of a TBI must be made by a physician? If there is not, can a state law require a physician make the diagnosis? As a nurse practitioner, making the diagnosis is within our scope of practice, but the state mandates the diagnosis be made by a physician.
I'd have to take a look at the state law to be sure, because, well, let me back up. There's a couple ways I can answer that. When we talk about an IEP and falling within one of the classifications, let's say TBI, then the law says it's the IEP team that determines whether the child qualifies. And there is no checklist, if you will, that says you must have this, and you must have this in order to conclude the child qualifies as TBI and gets an IEP. It's purely the judgment call of the IEP team, subject, of course, to challenge in a hearing and so forth. Now, having said that, a particular state theoretically could say that in order to give an IEP for TBI, you must have a physician who makes that diagnosis. Technically, that could be the case. Assuming that the law is not that kind of law, but rather talks about professionals and their scope of practice, then if a physician is the only one who is licensed to diagnose a brain injury, that doesn't mean that you have to have that physician's diagnosis in order for the IEP team to conclude that the child is TBI as an educational matter. So unless the state law is explicit, I think the IEP team could still, without the doctor's diagnosis, but you're going to need some medical documentation of the injury, but you don't literally need the diagnosis. So I think that's the best answer I can give you.
Okay, another question. Under Child Find, are school districts responsible for finding individuals with disabilities in the community as well? And can you give some examples of how they would go about doing that?
The obligation to those in the community would only be once they are eligible under the law for services from the district. So under IDEA applies to children ages 3 to 21 unless the state cuts it off before 21. So upon a child's 3rd birthday, if the child is really disabled, he or she is entitled to that IEP and all the services. So the school district would have an obligation to locate and identify kids as young as 3. How do you go about doing that? Well, you probably need to enlist some kind of a census that you do annually, no less frequent than every 2 years, of going out to the homes in the school district and trying to get information about the population so that you know ahead of time, ideally, that you got a 1-year-old child who's got a disability, and you track that so that before the 3rd birthday you're reaching out and trying to get the child evaluated so services start on the 3rd birthday. Now, people who are not enrolled in the public schools, who are not attending, in other words, if you've got a child who is 10 years old and attending a private school, resides in the district, attends a private school, you may not have an obligation for that child. It depends on what your state laws say. The federal law would put the obligation to serve any services for that child are going to be where the private school is located, not where the child resides. That's a whole other area.
Thank you, Bruce. Our final question before we let you loose. Are there any mechanisms in place to help ensure that school districts comply with the new law? Do you know?
When you say the new law, I'm not sure if you're talking about that mitigation piece.
The sports concussion law, I believe.
Oh, the New York State law, yeah. Now that's where that's where the 504 and IDEA come in. Those are the enforcement mechanisms if you can qualify. Otherwise, there is no enforcement mechanism other than a complaint to the State Education Department, which technically you can do. Practically, it takes forever and doesn't get you much results.
Thank you, Bruce. Thank you so much for being here today. Thank you, everybody, for tuning in. I appreciate all of your participation in our webinar. Again, you will get a follow-up email with some contact information in there with my email address. Feel free to email me. I'll get questions to Bruce. Check our website. We are having webinars every month where we will have another one. Hopefully we'll have to do a little bit more with concussion and the new law. So stay tuned for that. Check our website. Again, thank you everyone for being here. Thank you, Bruce. I appreciate your presentation. It was very, very informative. So thank you. Have a great day, everybody.